The Whitfield family and the Ramos family have almost identical situations. Both couples own their homes outright. No mortgage, paid off years ago. Both houses worth somewhere around $300,000. Both couples are in their late 70s. In the same year, a spouse in each family ends up in a nursing home, and Medicaid picks up the bill. Same law applies to both of them, same federal program. And when it's over, one family keeps the entire house. The other loses almost all of it to the state. Same amount of money paid out, same rules on paper, completely different outcome. And it has almost nothing to do with which family planned better. Quick refresher in case any of this is new. When someone goes on Medicaid for a nursing home, the house isn't counted against them while they're alive. It's exempt. But after they pass away, the state is allowed to file a claim against whatever they left behind to get some of that money back. It's called Medicaid estate recovery. It's been federal law since 1993, and at somewhere around $100,000 a year for nursing home care, 2 years of coverage is already past $200,000 owed. Both families knew this much. Both families thought a paid-off house made them safe. Only one of them actually was. Here's where it splits. The Whitfields live in Massachusetts. The Ramos family lives in Texas. That alone matters more than almost anything else in this story. 5 states, Massachusetts, New York, Ohio, Pennsylvania, and Wisconsin, account for close to 40% of every dollar collected through estate recovery nationwide. Most other states barely enforce this in practice. So the Whitfields were already standing in one of the 5 states most likely to come after a house. The Ramos family wasn't. But it's not only geography, it's paperwork nobody explained to either of them. The Whitfields' house was deeded solely in the husband's name, the one who ended up needing care. When he passed, that house had to go through probate, the court process for settling an estate, and Massachusetts recovers from the full probate estate. The Ramos family's house happened to be deeded jointly with right of survivorship years earlier for reasons that had nothing to do with Medicaid planning. When the Ramos husband passed, the house passed directly to his wife the same day. It never touched probate. And Texas, like roughly a third of states, only recovers from the probate estate, nothing else. No trust, no attorney, no clever move. Just how a deed happened to be worded a decade earlier. Before this starts to sound like a guaranteed disaster for anyone in the wrong state, here's some context that puts the whole thing in perspective. Nationally, states collect somewhere around $700 million a year through estate recovery. Medicaid spends over $600 billion. That's a recovery rate of roughly 0.1%. A federal oversight group has actually pointed out that the cost of running these recovery programs might be close to what states get back from them. So this isn't some efficient machine quietly draining every family that qualifies. It's inconsistent, unevenly enforced, and in most places, barely enforced at all. That doesn't help the Whitfields. It just means their outcome is closer to the exception than the rule. There's another wrinkle worth knowing, and it has nothing to do with geography. Some states won't even open a file if the estate is small enough. Texas won't pursue recovery on an estate under $10,000. Georgia's line is $25,000. Somewhere, someone ran the math and decided that below a certain number, it costs more to collect than it's worth. Then there's the caregiver situation, which trips up more families than anything else on this list. Say a couple, the Chens, have an adult daughter who moves back in for 2 years to take care of her father before he goes into a nursing home. Most people have heard that this protects the house. It can, but that protection is a federal option, not a federal requirement, and only 14 states actually run a functioning program for it. In the other states, it might technically exist on paper, but good luck finding someone who processes it correctly or tells the family how to document it. The Chens assumed the rule applied everywhere. It doesn't. Here's a distinction almost nobody gets right. If a Medicaid recipient dies and leaves behind a disabled child or a child under 21, most states don't cancel the debt. They pause it. Recovery comes back later once the child turns 21 or the situation changes. Deferred and forgiven sound like the same thing. They're not even close. A couple of states, Utah and Louisiana, actually wrote full forgiveness into their laws for that exact scenario. Everywhere else, it's a delay with your name still on it. A handful of states go even further and look at the heir's income, not just what the parents owned. Louisiana waives recovery entirely if the heir makes under 300% of the federal poverty level. Vermont does something similar, but only if the whole estate is under $250,000. In those states, what you personally earn for a living can decide whether your parents' house gets taken, regardless of how much your parents actually had. There's also a carve-out that barely comes up outside of farming families. 41 states have some version of a hardship waiver specifically built to protect a family farm or small business if it's the heir's main source of income. Nobody advertises this. If your family runs a farm and nobody mentions it during probate, you're not going to think to ask. And one thing that should actually calm you down a little: whatever gets recovered is capped at exactly what Medicaid paid out. No interest, no penalty, nothing extra tacked on. It's treated like any other creditor, which usually means funeral costs and administrative expenses get paid first. If the estate isn't big enough to cover the whole bill, the state writes off the rest. Nobody inherits a Medicaid debt into their own personal bank account. The house is at risk. Your own savings generally aren't. Now here's the part I've been holding back because it changes the whole premise of this video. Everything so far has been about what happens after someone dies. That's the assumption almost every article on this topic runs on, mine included until a minute ago. Paid off house, Medicaid can't touch it while you're alive, sort the rest out later. Except, under a federal law from 1982, states can place something called a TEFRA lien directly on a living person's home while they're still alive, the moment the state decides they're permanently institutionalized, meaning not expected to ever come home. It doesn't force a sale on the spot, but the claim attaches to the property right then, potentially years before anyone dies, long before probate is even a word anyone in the family has said out loud. The Whitfields didn't hit this. The Ramos family didn't either. But it's sitting in federal law right now, and almost nobody outside elder law circles brings it up. So the paid-off house isn't the finish line everyone treats it as. What actually happens depends on your state, how the deed is worded, who's living in that house, and a set of federal exceptions most people never hear about until they're already in the middle of it. The Whitfields lost the house. The Ramos family didn't lose a dollar. Neither family did anything wrong. They just landed on different sides of a system that was never explained to either of them. If any part of your family's situation sounds like either of these, that's worth a real conversation with an elder law attorney before a health crisis makes the decision for you. And if you're wondering how a Medicaid Asset Protection Trust actually changes any of this, that's a completely different video, and the answer might surprise you. Drop your state in the comments. I want to see how many of you are sitting in one of those 5 aggressive states without realizing it.